Seguimos con la sesión. Y ahora se iniciará la segunda mesa redonda. Tenemos la suerte de contar con el director general de la DigiCom, don Cecilio Madero. Muchas gracias, Cecilio. Es un honor para todos nosotros estar aquí. We start with our second round table. Thank you very much. And thank you very much because we have two connection with through streaming with other part of the world. Really, we are in a more and more big world. Thank you very much. Beatriz, cuando quieras.
So good morning to everyone. It's a pleasure for me to moderate this session. As you can see, we have two speakers sitting at the table, and we have Pam on the screen. She's not able to attend the meeting today for a very good reason, because Pam is expecting, so congratulations on that, but she was not able to catch a flight. So the former session and the former panel, we've been talking about the ECM Plus directive. We've been talking about this directive in many competition fora, in many meetings and conferences. Obviously because it's a directive that was fully aimed at addressing issues related to competition enforcement. However, at the time of the negotiations of the ECM Plus, there was another European directive being discussed in Brussels. This was the Whistleblowers Directive, which also has to do with competition, with many other things, but also with competition enforcement. In fact, just a few weeks ago, on the 7th of October, the European Council formally adopted this new directive on whistleblowers protection, and the new rules will require the creation of safe channels for reporting both within an organization, private or public, and to public authorities. And it will also provide a high level of protection to whistleblowers against retaliation. And this will require national authorities to adequately inform citizens and train public officials on how to deal with whistleblowing. All member states have 2 years to transpose this directive. Under this directive, whistleblowers are defined as people speaking up when they encounter in the context of the work, so it's really fully addressed to workers or former employees, to speak up on wrongdoing that can harm the public interest. And this obviously includes also harming competition in the markets. For example, think about bid rigging in public procurement. So public whistleblower protection is currently covered in a very fragmented way. Only 10 member states have extensive legislation on whistleblowing. And at the EU level, we do have some legislation, but it's fully focused on the area of financial services. In 2017, while the Commission was thinking about this, preparing all the work for this directive, there was a study carried out for the Commission that estimated the loss of potential benefits due to the lack of whistleblower protection in public procurement alone to be in the range of 5.8 to 9.6 billion euros. So a lot of money that we are losing in that sense. To understand the implications of this new directive and the relevance of whistleblowers, in particular in cartel investigations, we have in this panel session an excellent group of excellent speakers, distinguished speakers, who will speak from different perspectives, and this will allow us to get a full picture of this to EU documents. Since September 2015, as I said, she coordinates the Greens EFA Group's Transparency and Democracy Priority, focusing notably on whistleblower protection, integrity in the EU institutions, and freedom of expression and information. And Pam has been very much involved in the negotiation of this directive at the European Parliament. On my left, I have Cecilio Madero Villarejo. He, as you all know, is currently the Acting Director General in DigiCom, and he's also Deputy Director General for Mergers. He joined the European Commission a long time ago, already in 1987, and he has held many different positions. And as you all know, also since May 2011, he's been the Deputy Director General for Antitrust and Cartels in DG Competition. So he has a broad experience of more than 32 years in competition, and in particular in DigiCom. And last but not least, Devon Mahoney. He's the founder and CEO of New Market International Consulting since April 2019. Before this, Devon has worked in the FBI since 1996 in very different positions, and in particular between 2015 and 2019, he was an FBI supervisory special agent assigned to International Corruption Unit. He's an expert in proactive investigative techniques through evidence collection and counterintelligence, and he currently conducts a lot of training sessions for competition authorities on the use of intelligence in cartel investigations. Presently, he's contracted by the DOJ, by the Department of Justice in the Antitrust Division, as the technical assistance coordinator responsible for coordinating and providing training in proactive investigative techniques used to combat competition cartels. So a big expert in the whistleblowers domain as well. So first of all, I would like to give the audience the opportunity to learn a little bit more about the new directive on whistleblowers. And let's start with you, Pam, that you've been, as I said before, involved very much in this negotiation of this directive. How exactly does the whistleblower directive protect whistleblowers in practice?
Thanks very much for having me. Sorry, as you said, that I couldn't join in person, but yes, I am practically 8 months pregnant, so it's very hard to, well, it's not allowed to fly anymore. So just to answer your question, because I know we don't have that much time, in practical terms, the directive protects workers in the public and private sector and has a very wide definition of workers, which includes civil servants, the self-employed, even shareholders and people in the management and supervisory bodies of a company. It covers volunteers and trainees, whether paid or unpaid. It also covers contractors, subcontractors, and suppliers, and people who uncover breaches even during a recruitment procedure. So even if they haven't been hired yet, but they find something whilst being recruited, they would be covered too, as well as ex-employees. In practical terms, what the directive does is protect people reporting on breaches of union law in a wide range of areas as well. So they're going from, for example, money laundering and terrorist financing to product safety, transport safety, protection of the environment, also consumer protection. As mentioned before, the breaches of internal market rules, which includes rules on competition and state aid, and also, for example, tax avoidance issues. And it protects people not only reporting on breaches of the union law, but attempts to abuse the spirit or undermine the purpose of a union law. So it goes a little bit beyond this kind of narrow definition of illegalities, which is something that we fought for very, very hard as well in the European Parliament. Specifically on how whistleblowers would be protected, the directive prohibits any form of retaliation against whistleblowers, and then it includes a non-exhaustive list, obviously, of what these retaliation measures could be. So that includes suspension, dismissal, demotion, harassment, discrimination. Any sort of work-related penalties would be prohibited. Not only are they prohibited, but the directive calls for the implementation of effective, proportionate, and dissuasive penalties, which have to be put in place against either natural or legal persons who attempt to prevent anyone from reporting, who, as I mentioned before, retaliate against whistleblowers, who even threaten retaliation against whistleblowers, or who, for example, bring, as the directive calls it, vexatious proceedings, so legal proceedings against whistleblowers in the attempt to prevent them from speaking up, and also penalties for anyone who reveals the identity of the whistleblower. Because one of the main protections also offered by the directive is the confidentiality of the report, and of course the confidentiality of the identity of the reporting person. Perhaps more interesting is that whistleblowers are not going to be liable for any sort of breach regarding the disclosure of information. So, for example, when it comes to defamation, when it comes to breaches of copyright, breaches of secrecy and data protection rules, and even in the case of disclosure of trade secrets, as long as they report a breach in accordance with the directive, they are not liable in judicial proceedings of that kind. Turning to the acquisition of information, and this I'll come back to a bit later, whistleblowers are not liable for the way in which they acquired the information, provided it doesn't constitute in itself a self-standing criminal offense. Again, I'll come back to that later when you ask me what to look out for in the transposition phase. Whistleblowers are also benefiting from a reverse burden of proof, which basically means that in the case of a judicial proceeding, once the whistleblower establishes that they reported in line with the directive and that they suffered retaliation, it is the burden goes onto the person who is retaliating against the whistleblower to prove that actually whatever they did to the whistleblower has absolutely nothing to do with the reporting and is justified. So, for example, in the case of a dismissal, it would be that the employer has to prove why it was correct to dismiss the employee and why that dismissal has nothing to do with the issues that they were reporting on, which is important to kind of restore the balance of power between the employee and the employer in cases like this. Finally, the directive calls for member states to ensure remedies and full compensation for damages suffered by whistleblowers, always, of course, in accordance with the national law. And it recommends access to financial and psychological support and calls for member states to ensure access to legal aid and to comprehensive and independent information and advice. So all in all, I think it's quite a complete directive, if I may say so. But of course, it's up to the member states to now transpose this within the next 2 years in an even more complete and thorough manner that really protects whistleblowers who are speaking out.
Thank you very much, Pam, for this very extensive summary of the directive. I guess that having clear rules on protecting whistleblowers is going to be very relevant to encourage more whistleblowers to come to us. But the truth is that we've had whistleblowers in all of our competition authorities in the past. I wanted, Cecilia, to ask you, what steps has the Commission taken in addition to this the whistleblower directive to facilitate the use of whistleblowers in cartel enforcement and general in competition activity?
Good morning to everybody. First of all, I should say thanks to José María Quemada, the Comisión Nacional. By the way, I'm making efforts to speak in English in my own country. It's the first time. It's the first time I do it because normally the rule is if I'm in Spain, I speak my language. So you should say thanks for it. Again, many thanks to José María, to the CNMC as a whole, with the exception of Beatriz.